Does it violate the First Amendment Establishment Clause for a school district to require the saying of a prayer that's non-denominational at the start of every school day? To find out, you have to read Engel versus Vitale, but it's 29 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a special series I'm doing on landmark cases related to religious liberty and freedom from religion. This is the case of Engel versus Vitale. This is a case from the United States Supreme Court from June 25th of 1962. The citation for this case is 370 U.S. 421. The issue in this case is whether it violates the First Amendment's freedom with respect to religious liberty for a school district to require the recitation of a non-denominational prayer at the beginning of each school day. The law you have to understand to appreciate the context of this case is simple. It's the First Amendment to the United States Constitution, which is the First Amendment to the Bill of Rights. It actually begins, that First Amendment begins as follows. We always think about the First Amendment being the freedom of speech, the freedom of the press, but it really begins like this. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And then it goes on to discuss other issues. That First Amendment has two different aspects. They call it the Establishment Clause and the Free Exercise Clause. The Establishment Clause has been held to prohibit the government from passing legislation that establishes an official religion or preferring one religion over another religion. So it enforces it's the embodiment of what we call the separation between church and state. That phrase, separation of church and state, is not in the Constitution, but that's what the Establishment Clause essentially embodies, that the government shall not endorse a specific religion or prefer one religion over another. And the free exercise part of that First Amendment, what that has been determined to mean is that it prohibits the government in most instances from interfering with a person's practice of their religion. So it allows the person to believe what they want, to practice their religion to the extent that they can without interfering with other crimes or laws or requirements of society. So what are the facts here? The facts are that the New York State Department of Regents, or Regents organization, passed a rule which was carried forward by the New Hyde Park Board of Education that required that a prayer be said out loud in the beginning of each school day. It could be done by the teacher, it could be done by a student, and the prayer was as follows: Almighty God, we acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teacher, and our country. That 22-word statement was going to be required to be read out loud every day, either by a teacher or a student. It did not require that any student actively say it. It allowed parents to opt out by they could send a letter saying, my child shouldn't be present for this, and they could leave the room. And it would not result in any adverse impact upon any student that didn't want to be involved. That's part of the rule here. So parents of 10 of the students filed the case alleging that this was an unconstitutional law. It violated the First Amendment, directing the use of prayer in public schools. So it goes to, first it's adjudicated in the state level, and the state Supreme Court, which is the lowest court, said it was okay, said it was not a violation of the Constitution. Goes to the Court of Appeals, which is the highest court in New York State, and they agree that it does not violate the Constitution. And then it goes to the federal system, it goes to the United States Supreme Court. And here we have a holding, we have a majority, a concurrence, and a dissent. The majority was written by Judge Black, Hugo Black, and he goes through the history first of why we came to America to begin with. He says, the majority recounts that England had an official religion, an official Book of Common Prayer, and it required people to attend church. It persecuted people if they didn't attend the right church, they didn't believe the right beliefs. And he said that the reason why many of the colonists came to America is to avoid, was to leave that kind of establishment situation where the government established an official religion. And he goes through the history of how James Madison and Thomas Jefferson crafted the Bill of Rights and specifically included the First Amendment as a protection from an establishment of religion. they goes through a bunch of different interesting aphorisms, truisms that are really interesting. One of them is that one of the greatest dangers to the freedom of the individual to worship in his own way lay in the government's placing its official stamp of approval on one kind of prayer or another, or one particular form of religion service. And this was an interesting one. The union of government and religion tends to destroy government and to degrade religion. And ultimately, after assessing the history of England and the colonists, and even how when the early colonists came to America, they tended to establish in the individual colonies of an official religion of individual colonies and persecuted others. And Judge Black in the majority says that the prayer itself is a religious activity. It's a solemn avowal of divine faith and a supplication from God for blessings, and that it's unconstitutional as an establishment clause violation to encourage recitation of that prayer in a public school. And the majority goes on to address, and interestingly, they address two things. First, they say the fact that it's a small 22-word little prayer does not change the analysis. And they say, this is an interesting quote, "It is proper to take alarm at the first experiment with our liberties. Who does not see that the same authority which can establish Christianity in exclusion of all other religions may establish with the same ease any particular sect of Christianity, of Christians, in exclusion of all other sects?" And so the other thing that they point out is that they recognize the fact that there is, in the beginning of every single United States Supreme Court presentation, there's a crier. There's a person who starts every single Supreme Court day with a supplication for the same kind of thing, praying for God's blessings. There is a concurrence by Judge Douglas, and Judge Douglas concurs with the result that it's an Establishment Clause violation, but reframes the question and says, the question is really this: can the government constitutionally finance a religious exercise? Because that's what's going on here. That teachers, a minuscule portion of the teacher's day, is being paid for to exercise religious practice by saying a prayer. And the answer is it's not constitutional to do that. And Judge Douglas acknowledges, though, that Congress, the House, the Senate, and the Supreme Court all have similar prayers that in the opening of their days. And lastly, there's a dissent by Justice Potter Stewart, that says that it does not violate the Free Exercise Clause because that's a compulsion of belief, and that's not what's going on here. And he says, with respect to the Establishment Clause, if this is an Establishment Clause violation, then there's a ton of other things, including, as was mentioned earlier, the Supreme Court opens with a prayer, the House, the Senate open with a prayer, the Star Spangled Banner lyrics talk about God, the presidential oath talks about God, the Pledge of Allegiance contains one nation under God. And this is just one of many examples that exist of recognizing that this is a country full of religious people whose institutions presuppose a supreme being. But once again, the holding in this case, the majority holding for landmark purposes, is that the state cannot hold prayers in a public school, even if it's not required and not tied to a particular religion. And that's the case of Engel versus Vitale. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.